Hi everyone, it's Evan Brown, your favorite technology and intellectual property attorney. You know, a lot of companies bring on independent contractors to develop content. It may be a photographer, it may be a designer, it may be some kind of consultant. Well, here are 3 common mistakes that you should avoid if you are a company looking to bring on an independent contractor to develop content. The first mistake you should avoid deals with intellectual property ownership. Did you know that unless the contract says otherwise, an independent contractor owns the content that it generates under the agreement? Well, to take care of this, the agreement should say that the work the independent contractor does is a work made for hire. Now, work made for hire has a pretty specific meaning under the Copyright Act, and not all deliverables will actually be works made for hire. So additionally, there should be language that says, to the extent the work product is not a work made for hire, the independent contractor assigns the intellectual property rights in those deliverables to the company. A second common mistake that companies make when they are hiring independent contractors to develop content is failing to deal with confidentiality. The agreement should be very clear about what is confidential information, and it should put restrictions on the independent contractor concerning what it can do with that information, how it uses it, and also to whom that information can be disclosed. The independent contractor is going to learn a lot about your company in the course of the engagement, who its customers are, who its vendors are, what its plans are, what its financial situation is. Well, the contract needs to put those things in writing, else you run the risk of losing trade secret protection, or perhaps even worse, that independent contractor may go to work for one of your competitors and tell everything he or she knows about your company. A third common mistake that you should avoid if you are a company hiring an independent contractor is failing to deal with defense and indemnification. Let's say that the independent contractor delivers to you a photo that he or she actually lifted from somewhere else. You get sued by the third-party photographer who actually owns the copyright. Well, isn't it only fair that you could look to your independent contractor to pick up the cost of the defense and if there's any judgment entered against you? Well, I hope you have found this information about independent contractor agreements to be useful and interesting. If there's anything I can help you with, please drop me a line or give me a call. Why don't you go over and read my blog at internetcases.com. Follow me on Twitter and Instagram at internetcases. If you've watched this video, be sure to leave a comment. Let me know that you watched it, like it, and please subscribe to this channel. Tune in next time for more information about law and technology. Thank you.